Dialysis. Right, it will be listed. Subject to compliance, it will be listed.
Adjournments, page 5, page 1, till number 1 to 4, page 2, till number 5 to 8, page 3, till number 9 to 17, page 4, till number 18 to 23.
20, my lord. Say number 20. We take them next week, my lord. I'm not well, my lord.
As requested. What else comes? List on Mundin Varan. List in the next week. Right. 18. 18.
20, my lord. 20.
Right. Serial number 20 only. 18th.
18, yes, my lord. Yes, my lord. Yes, I'm sorry. I'm sorry, my lord. I'm sorry.
Unfortunately, second time, till number 1. See.
Just 2 weeks time is related to the needful. Yes.
Number 2, LTT,
Same.
Radha, number 3, A. Venkatesh, Sharat S. Gowda,
Week's time may be granted for filing second set, my lord. Week's time.
2017 matter. Why do you want 2 weeks time?
I have filed it before single judge. It has come up before.
But when it has come before us?
First time.
First time.
Yes, time, my lord.
No, not first time.
Yes.
13/6/2022 only it was connected.
Yes, my lord. It is connected, but in my absence, it is connected because he has filed it in before the bench. I have filed it before.
First you said that it is connected just few days back. Now you say it is connected in your absence. Thereafter 2 years.
Week's time may be granted if it's second set.
Failing which the full shall stand.
Week's time may be granted, my lord.
It's week's time.
1 week.
number 4, O. Mahesh, Chetan B.
Appear for the appellant, my lord.
Who is R7?
My lord, in MFA 1674 of 2018, R7 Krishna Gowda is served. In 1673 and 1672, not claimed. Service may be held sufficient, my lord.
R6? No. Non-take. First matter is not claimed.
Alla fourth matter 1674 ಅಲ್ಲಿ signed is received.
Not claimed. 1674 ಅಲ್ಲಿ signed ಅಂತ ಇದೆ.
Signed ಅಂತ ಇದೆ, served ಅಂತ ಇದೆ.
Served ಅಂತ ಇದೆ.
So maybe held sufficient, my lord, in the other.
Service on respond number 7. I think respond number 7 has not, as per the postal endorsement, respond number 7 has not claimed the notice. He is already served in the connected matter. Under the circumstances, service on respond number 7 held sufficient. This is 4.4 and 4.1. Admit ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಇಲ್ಲ. MFA 4378 of 2018 by the claimant. There, my lord, notice to R1 and R2 dispensed with. That can't be done. Owner and policy holder.
Then you file application to recall that order.
Allah, he has to, Chetan has to file, Mr. Chetan has to file.
Yeah, why?
Otherwise, again, there will be a delay.
Yeah, whether they are challenged liability.
Yes.
And right. So they are also against quantum only.
Right. R1 is the owner, R2 is the policy holder.
Correct. See, he is taking that risk. Now, according to him, this is only against quantum. Whether he has disputed liability.
Right. What happens at the time of hearing, they may say, I'll take notice. That's why I'm allowed to cut short the delay. I'm making submission.
So, sorry, it's already held sufficient. Dispensed with.
Dispensed with
In
Karnataka.
what way they are connected? Common award or? Correct. Huh.
Connected claims, my lord.
Hmm.
3 appeals by the insurer.
Other two appeals. There were in all 3 petitions.
Yeah.
It is submitted that this matter is connected to, what is the number? These matters are connected. These matters are connected to MFA number so and so. List all the matters. They are before DB only together in the next week.
Technically, he has to take notice, my lord. That's what I have.
Okay. At date 18.
Please.
19th. 19th is which day? 19th. Compliance of office of charge sheet to be profiled to verify address of the appellant. Correct. Line A1. How appellants 1 and 2 are made as party when they are not party in the sessions court. Appellants are not the witnesses in the charge sheet, being the children of the deceased parents only. They have filed the present appeal challenging the order of acquittal. Appellant died. No, you have mentioned appellants are the witnesses, are not the witnesses in the charge sheet, being the children of deceased victim's son. That is one thing. State, who are the complainant? Mother is not made party. Please. Right, that is one thing. They were not the, that we can do. Charge sheet to be verified address of appellants. Correct provision of law. What is that IA1? IA1 is for condonation of lien. Section 4 of the Limitation Act anta barದಿದ್ದೀರಾ? Who the appellants 1 and 2 are made as party when they are not party. Will accept only this objection. I mean, your submission only regarding the objection number 1 and 3. Charge sheet copies ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Not necessary. Not necessary. All right, that is. But you have to correct the provision of law. Accepting the consultation will overrule. Office objection number 1 and 3 are overruled. ಎಲ್ಲಿದೆ ಆಧಾರ್ ಕಾರ್ಡ್? ಫಾದರ್ಸ್ ನೇಮ್ ಎಲ್ಲಿದೆ? ನಾರಾಯಣ ಸ್ವಾಮಿ. For compliance of office objection number 2, 1 week time is granted. ಬೇಕಾಗುತ್ತಲ್ಲ ರೆಫರ್ ಮಾಡೋದಕ್ಕೆ ಆಫ್ಟರ್ ಕನೆಕ್ಟಿಂಗ್
ಮೆಮೋದಲ್ಲಿ ಈ ತರ ಮೂವ್ ಮಾಡಿದಾರಂತೆ ಮೇಡಮ್, ಬಟ್ ಆದ್ರೆ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಆಫೀಸ್ ಅವ್ರು ಹೇಳಿದ್ರು.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ವೇರ್ ಇಸ್ ಯುವರ್ ಮೆಮೋ?
ಪೋಸ್ಟಿಂಗ್ ಮೆಮೋದಲ್ಲಿ ಹಾಸ್ಪಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಅದು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ.
This is MFA 4580, no? It is submitted that this matter is connected to ಅದು ಇನ್ನು FR ನಲ್ಲೇ ಇದೆಯಾ ಬೇರೆ ಮ್ಯಾಟ್ರಸ್ ಅಲ್ಲ ಮತ್ತೆ FR ನಂಬರ್ ಅಂತ ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? Why have you mentioned FR number in the memo for posting? It is 5620. It is submitted that this matter is connected to MSH number 7264. List both the matters together. Both counsel seek reference to the local adalat. Therefore, the matters refer to local adalat.
Number 7. Motion for CR.
Appellants correctly stated. New India Assurance Company. Correct. The petition, what was said in the petition? Whether the mistake has occurred in this award only or in the petition itself? Branch manager, New India Insurance. He must, whether he has a copy of the petition or a statement of objection. ಹಾಗಿದ್ರೆ ಅದನ್ನೇ ಎಂಡಾಸ್ ಮಾಡಿ ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ನೀವು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಇಟ್ಸ್ ರಾಂಗ್ಲಿ ಮೆನ್ಷನ್ಡ್ ಅಂತ ಒಂದು ಎಂಡಾಸ್ಮೆಂಟ್ ಮಾಡಿದ್ರಲ್ಲ. ಕರೆಕ್ಟ್, ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಬಟ್ ಯು ಮೇಕ್ ಎನ್ ಎಂಡಾಸ್ಮೆಂಟ್ ಇನ್ ದ ಅಪೀಲ್ ಮೆಮೋ ಇಟ್ಸ್ ರಾಂಗ್. ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಮಾಡ್ಕೊಳ್ರಿ, ಆಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ, ಅವ್ರಿಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ, ನಿಮಗಲ್ಲ. You make an endorsement to that effect. Where is the petition copy? You have the petition copy? You trial court alli helbeku adana. Alle helbekagitte. Anyway, all right, we'll accept it to make an endorsement. Learner counsel for the appellant submits that the name of the corporation is New India Assurance Company and not New India Assurance Insurance Company as stated in the Tribunal's award. The stated in the impugned award. Impugned award. It appears. It appears it was not brought to the notice of the tribunal during the pendency of the trial court, the pendency of the claim petition. The counsel for the appellant shall endorse the same in the cost title of the appeal memo. Office objection is disposed of accordingly. Adin maadidralli it is application idu application for you know office objection right list tomorrow for admission. Nale tomorrow.
Getting on it. Number 8. CH-6. Chandrasekhar Swami.
Insurance or okay. NSTC. Oh. In vehicle, this death. In local, you want it to be referred to. ಅದು ಮಾಡಿದ್ರು ಅಲ್ಲೇ ಆಗುತ್ತಲ್ಲ ನಿಮ್ಮ ಏನಿಲ್ಲ. ಎಷ್ಟು how much time will both counsel submit that the matter is likely to be settled, hence the matter is referred to local adalat. ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ? ಹಾಗಿದ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ? 843 days ಡಿಲೇ ಇದೆ. ಇಂಟ್ರೆಸ್ಟ್ I think somebody is ಬರ್ತಾರೆ ಏನಂತಾರೆ. Third, accepting the reasons assigned to explain the delay. Do not report this in filing the appeal is condoned in the interest of justice. IA 1 of 2021 is disposed of accordingly. Next to refer to the local.
Number 9, Janardhan Reddy.
What is to emergency notice ಮಾಡಲ್ವಾ ಈಗ ಟೈರ್ ಅಮೌಂಟ್ ಹೇಳಬೇಕು ಮತ್ತೆ ಸ್ಟೇ ಮಾಡಕ್ಕೆ ಏನಿದೆ ಅಂತ issue emergency notice. There are many respondents ಅಲ್ಲ ಎಲ್ಲರಿಗೂ ಹೋಗ್ಬೇಕು issue emergency notice to the respondent. And where have you said that you have deposited the entire amount? ಅಲ್ಲ where do we find that? Order sheet ಅಲ್ಲಿ ಇದೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಕ್ಕೆ ರೆಫರೆನ್ಸ್ you will deposit the entire amount. What is your liability? 90% ಅಂದ್ರೆ ಅಲ್ಲ ಎಷ್ಟಾಗುತ್ತೆ ಅದು this rule and this is against MVC 3751 of 2008. How much is awarded in 37? 52,91,500. You are going to deposit the entire amount. Issue method notice to the response. Interim stay of the execution of the infilled award. So, begin the middle work that is delay. Now, counsel for the appellant submits that ಏನಿಗೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರ ಅದು ಹಾಕಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಬಿಡಿ ಏನು ಅಲ್ಲ ಕರೆಕ್ಟ್ ದೇರ್ ಇಸ್ ಡಿಲೇ ಆಯ್ತು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ರೆ ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಯುವರ್ ಅಪರ್ಹೆನ್ಷನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ರೆ ಮೂವ್ ಮಾಡಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ಮೂವ್ ಮಾಡಿ ಅವಾಗ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ರೆಸ್ಪಾನ್ಸ್ ಪ್ಲೀಸ್ ಸರ್
I appear for the appellant in this matter. Insurance company appeal my lord challenging liability to pay the compensation. It is a case of death. My lord, there is a delay of 41 days in filing the appeal, my lord.
ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ issue notice to the response list on date 1 2 same ಇದರಲ್ಲಿ to the response list on
1 2
Fresh matters, number 12, Chantraj K.
case of death you are on the quantum which is the insurance in what is not there huh? No what is not considered according to you what is the error which is that the manager United India Insurance Company ಅದನ್ನೇ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಿದ್ದು ನೀವು ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾಕೆ ಸರಿ ಬರ್ಸೋದಿಲ್ಲ ಅದನ್ನ Ravishankar was submitting that this is not United India Insurance, it is United Assured. ಅಲ್ಲ ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಹೇಳೋದನ್ನ ರೆಕ್ಟಿಫೈ ಮಾಡಿಸ್ಬಿಟ್ರೆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲ ಫಿಕ್ಷನ್ ಅಲ್ಲೇ ಆಗಿದ್ರೆ ದಟ್ ಇಸ್ ಬಿ ಕ್ಯಾರಿಡ್ ಔಟ್ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ನೀವು ತಗೊಳ್ತೀರಾ ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಕೃಷ್ಣಸ್ವಾಮಿ ಅವರು N. Krishnaswamy, learned standing counsel for the second respondent, is requested to accept notice for the second respondent. Registration show his name in the causes accordingly. We shall file the wakalat in the registry. in 2 weeks. Appellant's counsel shall serve the copies on him. What about respond number 1? Ex parte. ಇವಾಗ ಕೊಡಿ ಕೊಟ್ಟ ಮೇಲೆ ಆರ್ಡರ್ ಸೈನ್ ಮಾಡಿ submits memo for dispensation of fees to respond number 1. Since the respond number 1 was ex parte and liability is fastened to the insurance. Liability is fastened to the second respondent. Notice to respond number 1 is dispensed with. Then ಏನಿದೆ admission ಬೇಕಾ records ಏನು salary records ಬೇಕಾಗುತ್ತಾ? Admit call for TCR. List after the receipt of TCR. File the wakalat in the register. Bachelor. Whether this was raised anywhere earlier. Whether this was raised anywhere earlier. Whether this was raised anywhere earlier, because that part becomes the part of the income. That becomes the part of the income. Future prospects also become the part of the income. Prospects, we add to that based on the income. Barely add the respondents concept. This is from Chikmagalur. Respondents. Admit call for TCRs, issue notice to the response. How much is our interim stay of execution of the impugned award? Subject to the deposit of yeah, when? No, 50% after deducting the TDS and thing. Yeah,
My lord, 24 lakhs after. Lord,
600 ಎಷ್ಟಾಗುತ್ತೆ?
More than
42 lakhs ಆಗುತ್ತೆ. 40 ಇಲ್ಲ ಕರೆಕ್ಟ್ 49 lakhs 50% ಎಷ್ಟಾಗುತ್ತೆ?
28 lakhs.
24 lakhs and odd ಆಗುತ್ತೆ. Okay. Execution of the impugned award subject to deposit of rupees 26 lakhs before the tribunal within 6 weeks. 6 weeks from the date of the reception copy of this order. List after 6 weeks. 20 list after the receipt of TCR. Payments, okay. Yes. In 30. ನಾವು ನೋಡ್ಲಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್. He did say that You have the judgment with you?
ಅದಾ
Sir, last time ಹೇಳಿದ್ರು ನಮ್ಗೂ
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದು ಪ್ರಮೇಳ ಕೇಸ್ ಹೇಳಿದ್ರಲ್ಲ ಮನೇಲಿ ಇದೆ madam.
ನಾನು ನೋಡ್ಲೇ ಇಲ್ಲ.
ಅದು ಇನ್ ದಟ್ ಕೇಸ್ ಇಟ್ ವಾಸ್ ಎ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫಾರ್
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದನ್ನ ಇಲ್ಲಿ ಡಿಸ್ಕಷನ್
ಇದು ಪ್ರೊಪ್ರೈಟರ್ಶಿಪ್ ಅದೇ ಅದಕ್ಕೆ ಡಿಸ್ಟಿಂಕ್ಷನ್ ಮಾಡಕ್ ಆಗತ್ತೆ ಏನೋ ಅಂತ ಕೇಳೋಣ ಅಂತ ಇಟ್ಟಿದ್ದೀವಿ.
you were there when this matter was this submission
ಲಾಸ್ಟ್ ಟೈಮ್
ಇರ್ಲಿಲ್ವಾ? Now he says, so he says that business is continued, therefore only on the loss of estate it has to be granted, not the loss of income anta. What is it? She has not continued according to the evidence. Whether evidence in the evidence it has come.
ಅವ್ರ ಹೆಸರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ನಡೀತಾ ಇದೆ ಅಂತ ರೆಕಾರ್ಡ್ ಆಗಿದೆ.
Internal page 9.
ಜಜ್ಮೆಂಟ್ ಕರೆಕ್ಟ್ ಅದೇ ಪೇಜ್.
Yes.
With the assistance of the supervisor, it is denied the suggestion that Kanta enterprises is not money in loss. And others are this is producing the audit report of Kanta enterprises. Now we take the documents regarding that income tax return and other relevant documents. We can rework it out and dispose model. They can produce the document. They are not getting any material before the trial.
First, that proposition, whatever you are submitting, can be accepted. That is the case in all cases where the husband or father is a government employee. If a compassionate ground appointment is given, then if your submission is accepted. See, ಈಗ ಈ ಬಿಸ್ನೆಸ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ. ಇಫ್ ಎ ಪರ್ಸನ್ ಇನ್ ದ ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಡೈಸ್ ಅಂಡ್ ಈಸ್ it is not referred in the judgment. Here it is P1678.
16, 17, 18 ಮೂರು ವರ್ಷದ ಹಾಕಿ
Submission.
ಇದನ್ನ ಬರೀಲಿಲ್ಲ, ಅಮೌಂಟ್ ಬರೀಲಿಲ್ಲ, ಬರಲ್ಲ ಆ ಡಾಕ್ಯುಮೆಂಟ್.
refer it to the ಲೋಕದಲ್ಲ documents ಬೇಕಲ್ಲ, ಅದಲ್ಲ. Only that here the trial court records are there in this case. No, PCRs ಬಂದಿಲ್ಲ. ನೀವು ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವಾಗ ನಿಮ್ಮತ್ತ ಇದ್ರೆ ಕಾಪೀಸ್ ಬಂದಿದೆ ಅಲ್ಲ PCR. ಲೋಕ ಅದಾಲತ್ಗೆ ಹೋದ್ರೆ ಅವ್ರಿಗೆ ರೆಕಾರ್ಡ್ ಬೇಕು. ಅದಕ್ಕೆ ರೆಫರ್ ಟು ಲೋಕ ಅದಾಲತ್.
Pradeep.
Was drawing 15,000. This was in the year 2017. This judgment is in 2017. ಅವಾಗಿನ್ನೂ ಇದು ಬಂದಿರ್ಲಿಲ್ವಲ್ಲ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಅಂಡ್ ಕನ್ಸರ್ಷನ್ ಅದಕ್ಕೆ. ಸೊ ಇಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡೋದ ಲೋಕದಲ್ಲೇ ಕಳಿಸಿ ಬಂದಿದೆಯಾ ಯಾಕೆ ಅಂದ್ರೆ no, what was the document produced in proof of employment? Salaries. Certificate exhibit P9. What is the election? In this exhibit P11 and 12, the occupation is not mentioned. The ration card and election ID. ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಅದ್ರಲ್ಲಿ ಬಂದಿರೋದಿಲ್ಲ. ವೋಟರ್ಸ್ ID, ರೇಷನ್ ಕಾರ್ಡ್, ಫೋರ್ತ್ ಪಿಟಿಷನರ್ ದಟ್ ಈಸ್ ಕಾಪಿ ಆಫ್ ಐಡೆಂಟಿಟಿ ಕಾರ್ಡ್ ಆಫ್ ಪಿಟಿಷನರ್ ಅದು ಕಾಪಿ ಆಫ್ ದ ರಿಜಿಸ್ಟರ್ ಆಫ್ ಅಟೆಂಡೆನ್ಸ್. ಅಲ್ಲ ಏನ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ that was disputed by you, employment? Salary slip ಅದು ಯಾವ್ದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ? Salary certificate. Who has issued salary certificate? That is PW. PW. Why is suspected his employment? Not disputed that he was working as headmaster. Other dispute padidare. Record. First we will see whether he had disputed he being the employee. Cross examination. PW1. Who is that person? Employer?
Ashok.
PW1 is PW3. It is a cross examination. This certificate. Charge sheet copy ಹಾಕಿದ್ದೀರಾ? Charge sheet copy ಅಲ್ಲಿ what is his occupation is shown as exhibit ಎಷ್ಟು charge sheet?
Exhibit P6.
ಅದೇ ಹೌದು ಅದು ಮಾಡ್ತಾರೆ ಅಂತ ನಾವು ಕೇಳಿದ್ವಿ. ಅವರಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯೀಸ್ ಆರ್ ನಾಟ್ ಸಪೋಸ್ ಟು ಡೂ ಎನಿ ಅದರ್ ಬಿಸ್ನೆಸ್. ಇವ್ರು ಗವರ್ಮೆಂಟ್ ಅಲ್ಲ, ಪ್ರೈವೇಟ್ ಅನ್ಕೊಂಡು, ಬಟ್ ವಿ ಆರ್ ಟೋಲ್ಡ್ even university professors do the money lending business anta. When we're working in Mysore, some recovery suits bandidralli appeal alli Angi Ramaya. ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಇದ್ರ ಬಗ್ಗೆ ಏನು ಬಂದೇ ಇಲ್ಲ. ಟೈಮ್ಸ್ ಯಾವ್ದಾದ್ರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೀಗೆ ಬಂದಿರುತ್ತೆ ಅಂತ ನೋಡೋಣ. ಇನ್ಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾರೆ, ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಮದರ್ ತೆರಾಸಾ ಮೆಮೋರಿಯಲ್ ಇಂಗ್ಲಿಷ್ ಸ್ಕೂಲ್ ಎಂತದ್ದು ಉಪಾಧ್ಯಾಯರು ಅಂತ ಇದೆ. ಉಪಾಧ್ಯಾಯರು ಅಂತ ಇದೆ, ಮುಖ್ಯೋಪಾಧ್ಯಾಯರು ಅಂತ ಇಲ್ಲ, ಬಟ್ ಇದು ನೋಡಿ ಉಪಾಧ್ಯಾಯ. ಅವಾಗ ಎಲ್ಲಿ ಅವ್ರಿಗೆ ಸ್ಕೋಪ್ ಇರುತ್ತೆ. ಹಾಗಲ್ಲ, ಅವರು merely because they had employed an ineligible candidate, whether these people can be deprived or now there is no reason to disbelieve that he was a teacher in the school. ಯಾಕಂದ್ರೆ ಇನ್ಕ್ವೆಸ್ಟ್ ಅಲ್ಲಿ ಅವಾಗಿನ ಅಷ್ಟು ಶಾರ್ಟ್ ಟೈಮ್ ನಲ್ಲಿ they can't concoct the things. No salaries. ಅದಕ್ಕೆ ಈಗ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW1 ನೋಡೋಣ. ಇನ್ಕಮ್ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಏನಿದೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದೀರ ಅದಕ್ಕೆ? ಶಾಲೆಯಲ್ಲಿ ಕೆಲಸವಾಗ್ಲಿ ಅಥವಾ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ವ್ಯವಹಾರವಾಗ್ಲಿ ಮಾಡುತ್ತಿರಲ್ಲ. ಅವ್ರಿಗೆ 30,000 ಆದಾಯ ಕೂಡ ಇರ್ಲಿಲ್ಲ ಅಂತ ಸುಳ್ಳು ಹೇಳ್ತೀನಿ. ದಟ್ ಇಸ್ PW ಎಷ್ಟವರು ಎಂಪ್ಲಾಯರ್ PW3 ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಇಶ್ಯೂ ಮಾಡಿದವರು PW3 ಇವ್ರು ಇಶ್ಯೂ ಮಾಡಿದ್ರು. ಕರೆಕ್ಟ್, ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಇಶ್ಯೂ ಮಾಡಿದವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಹೂ ಇಸ್ PW3 ನ ಹೂ ಸಿಗ್ನೇಚರ್ ಇಟ್ ಬೇಸ್ ಎಕ್ಸಿಬಿಟ್ P9. P9 headmaster. Just to certify that. 7 years time. ಯಾಕೆ ಹೆಡ್ಮಾಸ್ಟರ್ ಯಾಕೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್? ಅವ್ರಿಗೆ ಯಾರೋ ಸೆಕ್ರೆಟರಿ ಅವ್ರು ಯಾರೋ ಇರ್ತಾರಲ್ವಾ ಇಶ್ಯೂ ಮಾಡೋದಕ್ಕೆ. ಹೆಡ್ಮಾಸ್ಟರ್ ವಿಲ್ ನಾಟ್ ಇಶ್ಯೂ ದ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್. ಮಾಡ್ತಾರೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಕೆಪಾಸಿಟಿಯಲ್ಲಿ ಮಾಡ್ತಾರೆ. ಇಲ್ಲ ಇರ್ಬೋದು ಸಮ್. ಈಗ ಗವರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ಸ್ ಅಲ್ಲೆಲ್ಲ ಬೇರೆ ಬರೀ ಪ್ರೈವೇಟ್ ಸೊಸೈಟೀಸ್ ಅಲ್ಲಿ ಇರೋದು. ಗವರ್ಮೆಂಟ್ ಸ್ಕೂಲ್ ಅಲ್ಲೆಲ್ಲ ಅವರೇ ಇಶ್ಯೂ ಮಾಡೋದು. ಆಯ್ತು, ಇವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡೋಣ. ಯಾರು PW3 ನ 2002ನೇ ಸಾಲಿನ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ESI GPF ಸೌಲಭ್ಯ ಇರುವುದಿಲ್ಲ. ಇದೆಂತದ್ರಿ ಸ್ಕೂಲ್? ಶಾಲೆಯ ಖರ್ಚು ವೆಚ್ಚ ನೋಡಿಕೊಳ್ಳಲು ಲೆಕ್ಕ ವಿಭಾಗ ಇದೆ. ಪ್ರತ್ಯೇಕ ಲೆಕ್ಕ ವಿಭಾಗ ಇರುವುದಿಲ್ಲ ಅಂತ, ಸಪರೇಟ್ ಅಕೌಂಟ್ಸ್ ಬ್ರಾಂಚ್ ಇಲ್ಲ ಅಂತ. ಅದನ್ನು ನಮ್ಮ ಶಾಲೆಯ ಮುಖ್ಯೋಪಾಧ್ಯಾಯರು ನೋಡಿಕೊಳ್ಳುತ್ತಾರೆ. What is the date of accident? So ನೀವು 15,000 ಕೊಡ್ತಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಷ್ಟು ಕೊಡ್ತಿದ್ರು ಅಂತ ನಿಮ್ ಕೇಸ್?
14,6,2000 ಚಾರ್ಟ್ ಕೊಡಿ ಮೇಡಮ್.
Date of accident is
2015.
2015.
ಮತ್ತೇನ್ ಬರೋಬರ್ ಐತಿ
ಅಲ್ಲ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಡ್ಬೇಕು.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಡ್ಬೇಕು.
30,35,000 is awarded. What is the income considered by them?
10,000.
10,000. Future prospects ಸೇರಿಸ್ಬೇಕಾಗುತ್ತೆ. Disbelieve. We are also not done. ಯಾಕೆ disbelieve ಮಾಡಬೇಕು? Say.
ಎಜುಕೇಶನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್
ನೀವು ಒಂದ್ಸರಿ ಈ ಕಡೆ ಕುತ್ಕೊಂಡು ನೋಡ್ಬೇಕು ಹೇಗೆ ಸ್ಯಾಲ್ರಿ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಪ್ರೈವೇಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ಪಾಪ ಫಾರ್ ದಟ್ ವೈ ದೇ ಶುಡ್ ಬಿ ಪೆನಲೈಸ್ಡ್. ಕರೆಕ್ಟ್, ಅದಕ್ಕೆ ಅವರು ಏನು ಕೊಡೋದಿಲ್ಲ ಏನಾದ್ರೂ ಕೇಸ್ ಆದ್ರೆ ಅಂತ ಹೇಳಿ ಸ್ಯಾಲ್ರಿ. How that criminal considered it as 10,000 or 15,000 ಬೇಡ ಅಂದ್ರೆ 10,000 ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು? ಅಲ್ಲ 10,000 ಹೆಂಗ್ ತಗೊಂಡ್ರು? ಅವಾಗ ಇನ್ಕಮ್ ಇದು 2016 ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು?
9,000 ಇತ್ತು.
16 ಅಲ್ವಾ? You said
ಆಕ್ಸಿಡೆಂಟ್ 15.
9,000.
9,000 ಇತ್ತು. 1,000 ಕಡಿಮೆ.
ಅಲ್ಲ ಅವ್ರು 15,000 ಅವ್ರ ಪ್ರಕಾರ. ಅಲ್ಲ ಯಾಕೆಂದ್ರೆ ಅದನ್ನ ಪೂರ್ತಿ ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡೋದಕ್ಕೆ ಸಾಧ್ಯ ಆಗಿಲ್ಲ. Even the conscience of the judge has not
permitted to totally discard.
Head master ಇದವರಿಗೆ ಆ ಒರಿಜಿನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಂತ. ಬೇಸ್ಡ್ ಆನ್ ವಾಟ್ ದಿಸ್ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ವಾಸ್ ಇಶ್ಯೂಡ್. ಅಂದ್ರೆ ರೋಲ್ ಆಫ್ ಪೇಮೆಂಟ್ ಅದೆಲ್ಲ ಇಲ್ಲ ಅಂತ. ಅಕ್ವಿಟೆನ್ಸ್ ರೂಲ್. ವಾಟ್ ಈಸ್ ಟೀಚರ್ ಅವ್ರು ಹೇಳೋದು, ಟೀಚರ್ ಈಗ ಆಯ್ತು ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಯು ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. ವಾಟ್ ಈಸ್ ದ ಬೇಸಿಸ್ ಫಾರ್ ದ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್? ದೇರ್ ವಿಲ್ ಬಿ ಸಮ್ ಅಕ್ವಿಟೆನ್ಸ್ ರೋಲ್ಸ್ ಆರ್ ಪೇಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಇರುತ್ತೆ, ಅದನ್ನ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳೋದು. ಪ್ರೈಮರಿ ಡಾಕ್ಯುಮೆಂಟ್ ವಾಸ್ ನಾಟ್ ದೇರ್. ಈಗಾದ್ರೂ ನಿಮ್ಗೆ ಯು ವಿಲ್ ಗೆಟ್ ದಿಸ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಅಲ್ಲಿ ಸರಿ ಹೋಗುತ್ತೆ. ಸ್ಟ್ರಿಕ್ಟ್ಲಿ ಇಫ್ ಯು ಗೋ ಬೈ ದಿಸ್, ಅಲ್ಲಿ ಉಪಾಧ್ಯಾಯರು ಅಂತ ಇದೆ ನಿಮ್ಮ ಇನ್ಕ್ವೆಸ್ಟ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ, ಮುಖ್ಯೋಪಾಧ್ಯಾಯರು ಅಂತ ಇಲ್ಲ. ಯು ಶುಡ್ ಹ್ಯಾವ್ ಪ್ರೂವ್ಡ್ ಇಟ್ ಅಲ್ವಾ? ಅವ್ರ ರಿಜಿಸ್ಟರ್ ಆದ್ರೂ ಸಮನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ನೀವು. ಬೇರೆ ರಿಜಿಸ್ಟರ್
10,000 ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ರೆ
10,000 ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಎಷ್ಟಾಗುತ್ತೆ? He was 46. 45 ನ 46 PM ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ 46 ಅಂತ ಇದೆ ಅಂತ SSLC ವರ್ಷ. ಸೊ 45 ಪ್ಲಸ್ 45 ಇಯರ್ಸ್ ಗೆ ಎಷ್ಟು? ಪರ್ಮನೆಂಟ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ 40% ಆಗುತ್ತಾ? 40 years, 45 years. So 2,500. 12,500. Personal expenses ಎಷ್ಟಾಗಿದೆ? 3/4 ತಗೋಬೇಕು. 12,500 into 3 divided by 4. 9,3 ಎಷ್ಟು? ಇಂಟು ಎಷ್ಟು? ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇಸ್ 14. ಮಲ್ಟಿಪ್ಲೈಯರ್ ಎಷ್ಟು? 12 into 14. 15 lakhs. Then consortium, 44 into 4. Like 76. And funeral expenses 33. ಎಷ್ಟು 33,000. Total 15,75,000. 17,84,000. Was awarded. How much will be enhanced? 13 lakhs to 17 lakhs. 4 lakhs. 4 lakhs. Taken for final disposal. ಲೋಕದಾಲತ್ತಲ್ಲೇ ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ ನೀವಷ್ಟು. Another compensation awarded to the appellant. By that result, by the input award, with just is the question involved in this case. Appellants are the wife, son, daughter, and mother of deceased. In this Narayan Swami, na? But Sampangi Ramaya. Sampangi. Sampangi Ramaya. On 14/6/2015 at 5 p.m. when Sampangi Ramaya was traveling on his motorcycle number K05 HE5338 near Smunali Lake Road, South Taluk. So there were two petitions. One, they are injured, a pillion rider. Lorry bearing number K03 C353 hit the said motorcycle. Consequent to the injury suffered in the accident, Sampangi Ramaya died on the spot. In the accident, Sampangi Ramaya suffered grievous injuries and he was being shifted to the date of what is the date of death? Certainly, he was shifted. He was initially shifted to Sairam Hospital and from there to Victoria Hospital. He succumbed to the injuries on the way to Victoria Hospital. On the same day, at the relevant time, respondent number 1 was the insurer and respondent number 2 was the registered owner of the lorry number KA03 C353 KA03 and the appellant filed LVC number 3216 of 2015 against the response before the 22nd AC additional 22nd additional smart cottage and NACT claiming bracket ಏನದು SCCH 24 claiming compensation of ₹55 lakhs on the ground that they are all dependents of Sampangi Ramaya and due to his death they have suffered damages. They claimed that the accident took place due to rashness and negligence of the driving of lorry number KA03 C353 and the response being the owner and insurer are liable to pay the compensation. Only you have contested or both the Ibru contest ಮಾಡಿದ್ದಾರೆ. Somebody has appeared for them also. Our statement of objection ಆಗಿದ್ರು ಇಲ್ಲ. Second respondent denied the date of time ಮಾಡಿದ್ದಾರೆ. The response contested the petition, denying the accident from a rash negligence on the part of the driver of the lorry, age, occupation, income and dependency of the petitioners, claimant, appellants. Respondent number 1 disputed its liability to pay the compensation. Respondent Ibru disputed and their liability to pay the compensation. The parties adduced evidence. The tribunal by the impugned award granted compensation of rupees
13,55,000.
13,35,000 on various heads as per the table below. 33 of the paper book. The tribunal held that the claimants at the appellant the appellants have failed to prove that deceased was getting salary of rupees 15,000. However, notionally considered his income at rupees 10,000 per month. Conversion 20,000, loss of love and affection 40,000 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಷ್ಟು ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? Out of that, the tribunal deducted 1/4 for the personal expense of the deceased, applied multiplier, 14 multiplier, and assessed a loss of dependency at rupees 12,60,000. Next. Reiterating the grounds of the appeal, pursuant to 11,000 for the appellant submits that the tribunal was not justified in rejecting the evidence of PW 3 the 3 and exhibit P9 the salary certificate and their contention that the petitioner, the deceased was drawing the salary of rupees 15,000. It further contended that the tribunal committed error in not awarding the future prospects and the consortium to all the appellants. Next one. Per contra, he saw justifies the impugned award, saying that contending that the evidence of PW3 and exhibit P9 were not reliable, and no primary document in proof of the rate of salary and dispersal of the salary was produced. Thus, he seeks dismissal of the appeal. Next paragraph. The finding of the tribunal that the accident occurred due to rash and negligent driving of a lorry number A03C0353 is not challenged by the respondent. The age of the deceased as per the exhibit SSL P19 they have the claimants as per P19 SSL march card of the deceased was 45 years. P19
It's also marks.
what was his performance? Very passive.
281
281 marks. ಎಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಆಗುತ್ತೆ ಅದು 281 ಅಂದ್ರೆ 6 subjects 6 subjects
281.
percent 46 point
46.8.
45 45 yes. Is it P9 the salary certificate was issued by PW3? The present the headmaster who was successor to the deceased in the institution. The primary, though that was disputed, the primary evidence of exhibit P9, like acquittance rule, was not produced. No bank records were produced to show that the salary at the rate of 15,000 was disbursed to the deceased. Under the circumstances, the tribunal rightly did not accept the evidence of PW3 and exhibit P9 as the primary evidence of the income of actual P9 of proof of income of this 15,000 per month as salary. That tribunal was justified in not assessing the income at 10,000 as there was no other evidence actual proof of the deceased. In view of the judgment of the Supreme Court in Pranay Sethi and Magma Corporation, the tribunal should have awarded future prospects at the rate of 25%. 35%. In addition to the income of the said notional income of this for 10,000 per month. Since the deceased had dependents, 4 dependents, as per Sarala Verma's case, ಅವರು ಅಷ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ 1/4. The tribunal was justified in deducting 1/4 of the income for personal expenses. After deducting 1/4 out of rupees 10,000 plus 2,500, money is 12,500. The loss of income of the deceased payable by way of compensation comes to rupees 9,375
Into 12 into 14.
into 12 into 14 to 15,75,000. As per the judgment, the consortium payable to the appellants with the enhancement of division of 10% hike comes to rupees only 44,000 into 4 ಮಾಡ್ಕೊಳ್ಳಿ 1,74,000 76,000. The compensation payable on the conventional heads of funeral expenses and loss of estate comes to rupees 33,000. Therefore, the just compensation payable is as follows: loss of dependency 15,75,000, consortium 1,76,000, convention funeral expense and loss of estate 33,000, 17,84,000. Therefore, the order of the tribunal needs to be modified accordingly. The following order, the appeal is partly alone. The impugned award is modified as follows. Appellants claimants are entitled to compensation of 17,84,000 with interest thereon at 6% per annum from the date 8% ಕೊಟ್ಟಿದಾರಲ್ಲ from the date of ನೀವೇನು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿಲ್ವಲ್ಲ ಅದ್ರ ಮೇಲೆ 6% per annum from the date of the petition till the date of deposit. Respond number 2 ಅಲ್ಲ 1 ಅಲ್ವಾ ನೀವು respond number 1 shall deposit the said amount before the tribunal within 6 weeks. 6 weeks from the date of this order. The first respondent is entitled to adjust the amount in making such deposit. The first respondent is entitled to adjust the amount already paid. The order of the tribunal with regard to apportionment and investment is maintained. 6%. And 6% on enhancement. All right. Victim supported or not?
Mentally.
Mentally challenged. How the victim was examined if she was mentally challenged? Any expert was?
Examine ಮಾಡಿದಾರೆ ಕೋರ್ಟ್ ನವರು ಆಫೀಸರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. She is capable of giving answer ಅಂತ ತಿಳ್ಕೊಂಡು ಆಕೆ ನೋಡೋದು.
Inner victim PW2. What was her disability? 75% disability.
IQ level 35%. IQ level 35. ಎಕ್ಸ್ಪರ್ಟ್ ಮಾಡಿಲ್ಲ.
ತಗೋಬೇಕಾಗಿತ್ತಲ್ವಾ? ಎಕ್ಸ್ಪರ್ಟ್ ತಗೋಬೇಕಾಗಿತ್ತು ಎವಿಡೆನ್ಸ್ ಮಾಡೋದಕ್ಕೆ. 35% IQ disability ಅಂತಂದ್ರೆ what was her age?
14. Told you.
Expert will admit this. Admit ಮಾಡಿ. Admit ಮಾಡಿ. Two things. One is the child is 12 years. 14 years with 32%.
35%.
35% of
IQ level.
IQ level ಅಂತಂದ್ರೆ ಎಕ್ಸ್ಪರ್ಟ್ ತಗೋಬೇಕಾಗಿತ್ತು ಅನ್ಸುತ್ತೆ.
ಕಾಲೇಜ್ ಅವ್ರನ್ನ ಓಪನ್ ಕೋರ್ಟ್ನಾಗ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಯಾರೆ. ಅವ್ರು ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಅವ್ರು ಉತ್ತರ ಕೊಟ್ಟಾಳಂತೆ. ಹಿಂಗೆ
ಇವನ್ 100% IQ ಇದ್ದವ್ರಿಗೂ
ಗೊತ್ತಾಗೋದು. That is the observation of the trial.
third matter requires detailed consideration.
Madam.
Third matter requires detailed consideration. Admit call for TCR. ಏನ್ ಬೇಲ್ ಆಗಿದೆಯಾ?
ಈಗ ಅಕ್ಯೂಟ್ ಆಗಿದೆ.
ಸರಿ ಅಲ್ಲೇ ಇದೆ. ಅಲ್ಲಿ was in judicial custody or during trial? What is his age? 23. Admit call for TCR. Paperwork shall be prepared within 4 weeks and within 4 weeks. List on 4 weeks and date. 13th. 13th. Monday. 13th year. What was the medical evidence? According to whether according to the prosecution there was penetrative sexual assault. Victim was you said Hardys. How old was your? How the child will say about that? Admit and call for the record.
Apportionment.
Sachin BS. Heard admit, heard matter request detailed consideration, admit all for TCR, paperwork shall be prepared within 4 weeks. This term 4 weeks of Second. What dates in the second matter? Yeah.
ಮೇಡಮ್ ಇದು ಒಂದು ಅಪ್ಲಿಕೇಶನ್
Order is already passed. When the order was passed? 2020. %50 of the deposit. The amount mentioned ಮಾಡಿದ್ದಾರೆ 9,47,161 ಅಂತ ಹೇಳಿ. You have to now I have one of two TCS. ಕಳ್ಸಲ್ಲ ಹೇಗಿದ್ರು ಇನ್ನು ಸೆಕೆಂಡ್ ಸೆಟ್ ಹಾಕಿಲ್ಲ. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಪೇಪರ್ ಬುಕ್ ಹಾಕಿ ಇದನ್ನ ಹಾಕಿದಿರಲ್ಲ. ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಸ್ ಇನ್ ಕ್ವಶನ್. ಸೊ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು. To hear the matter, records are required. I admit ಮಾಡಲ್ಲ. First matter ಅಲ್ಲಿ third admit. Second matter ಅಲ್ಲಿ IA is filed in the first matter. Return of TCI. LCR ಅವ್ರದ್ರಲ್ಲಿ ಬಂದು ಇದು ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಾರ ಅಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. Admit orders orders and this code by order dated 10/10/2022 has permitted the respondent claimants withdraw an amount of 9,47,161 deposited by the appellant. Tribunal before the tribunal. Therefore, to facilitate the withdrawal of the same, the TCS are required to be sent to the tribunal. Return the records to the tribunal. The tribunal shall resubmit the same soon after the purpose is over. List after 4 weeks and connected matter counsel for the appellant submits that he has submitted the second set. Registry shall verify and list after 4 weeks.
Number 90. Matter TC in business promise for R2.
What is the error in the award? Date of accident is 11/12/2008. Yes. What was the age of the deceased? The proof of actual income, according to what was he doing? In 2018, notional income is taken. Chat, chat. ಅದು ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಸೇರ್ಕೊಂಡು ಬಂತು ಅಂತ ನಿಮ್ದು ಹಾಗೆ ಮಾಡಿ. So it should have been taken at 9,000. Incorrect ಅಲ್ಲ, notional income ಆದ್ರೂ ಇಲ್ಲಿ 2014-15 8,500 to 9,000 ಇದೆ. So 2018, I'm sorry, 18 12,500 ಇದೆ. I'm sorry. ಎಷ್ಟು? 25% above 40. He was 40. ಎಷ್ಟು ಏಜ್ 48 ಅಲ್ಲ? 12,500 ಪ್ಲಸ್ ಎಷ್ಟು? 25% ಮಾಡಿ 3125 ಆಗುತ್ತಾ? ಅದರಲ್ಲಿ 3125 12,500 ಪ್ಲಸ್ 3,125 ಮಾಡಿ 15,000. ನೀವು ಚಾರ್ಜ್ ಮಾಡಿದ್ರೆ 15,625. ಪರ್ಸನಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಆಗಿಬೇಕು ಅದರಲ್ಲಿ. ಅಲ್ಲ ಅದೇ ನಾವೀಗ ಇಲ್ಲಿ ಮಾಡ್ಬೇಕಲ್ಲ, ಡಿವೈಡೆಡ್ ಬೈ 4 ಮಾಡಿ ಎಷ್ಟಾಗುತ್ತೆ? 15,625 ಡಿವೈಡೆಡ್ ಬೈ 4. 3906. ಅದರಲ್ಲಿ ಇಂಟು 3 ಮಾಡಿ ಮತ್ತೆ ಎಲ್ಲ ಎಷ್ಟು ಬರ್ತು? ಅದು 3,900. 718 ಅಂದ್ರೆ ಅದನ್ನ 19 ಮಾಡೋಣ. 75 ಬಂದಿದ್ರೆ ಇಂಟು 12 ಇಂಟು 13. ಪ್ಲಸ್ 28,600. ನೀವು ಅದನ್ನ ರೌಂಡ್ ಮಾಡಿರ್ಬೇಕು. 719 ಮಾಡಿದ್ದನ್ನ ನೀವು 720 ಮಾಡ್ಕೊಂಡಿರ್ಬೇಕು. 11,719 ಇಂಟು 12 ಇಂಟು 13. ಎರಡು ಕ್ಯಾಲ್ಕುಲೇಟರ್ ಬೇರೆ ಬೇರೆ ಹೇಳು. ನಿಮ್ದು ಎಷ್ಟು ಬಂತು? 64. ಆಮೇಲೆ ಕನ್ಸೋರ್ಷಿಯಂ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 25,000 ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್. ಕಾನ್ಸೋರ್ಷಿಯಂ 25,000. ಅದು 44,000 ಈಚ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ. 44,000 ಈಚ್. ನಾವು ರಿವಿಷನ್ ಆಫ್ 10%.
Since we are from the accident is from the year 2018, therefore 3 years on. Therefore
2000. ಈಗ ನೀವು ಕೊಡೋ ಹೊತ್ತಿಗೆ ಅಲ್ಲ, see that judgment was rendered in 2017 ಅಲ್ವಾ? Once in 3 years ಅಂದ್ರೆ ನೀವು ಕೊಡ್ತಿರೋದು ಈಗ 3 years ಆಗೋಗಿದೆ.
You adjudicate matter. Other action will get to 2018.
Once in 3 years.
Accident
ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಅಲ್ಲ ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಸ್ ಇಫ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ಟೇಕ್ಸ್ ಪ್ಲೇಸ್ ಇನ್ 2017 ಅಂತ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳದ ನೀವು? ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಯಾವ್ದು? ದಟ್ ಈಸ್ ಪ್ರಣಯ್ ಸೇಠಿಸ್ ಕೇಸ್. ಪ್ರಣಯ್ ಸೇಠಿ ಕೇಸ್ ಅಲ್ವಾ? ಪಾರ್ಟ್ ಆಫ್ ಲಾಸ್ಟ್ ಗೆ ಇದೆ ಅದು. ಇದೇನು ಈ ತರ ಇದು ತೆಗೆದುಕೊಟ್ಟಿದ್ದೀರಾ? ರೀಸನಬಲ್ ಫಿಗರ್ಸ್, ಕನ್ವೆನ್ಷನಲ್, ರೀಸನಬಲ್ ಫಿಗರ್ಸ್. Reasonable figures on conventional heads, namely loss of estate, loss of consortium and funeral expense should be 15,000, 40,000 and 15,000. The aforesaid amounts should be enhanced at the rate of 10% in every 3 years ಅಂತ ಹೇಳ್ತಾರೆ. ಹಾ.
ಅದನ್ನ ಮಾಡಿದ್ದು they decided at that time, 2017. ಅದು once in 3 years accidents after year.
ಡಿಫಿಕಲ್ಟ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಇಟ್ ಅಲ್ವಾ. ಈಗ ಒನ್ಸ್ ಇನ್ 3 years ಅದು ಆಗ್ಬೇಕು ಅಂತಂದ್ರೆ ಅದಕ್ಕಿಂತ ಪ್ರಯರ್ ಆಗಿರೋ is it your contention that the accidents which take place prior to the 2017 this does not apply at all?
Accidents ಸಹ adjudication percentage
ಹಾ.
ಮತ್ತು day percentage 10% tax ಮಾಡುವಾಗ adjudication 10% ಜಾಸ್ತಿ ಮಾಡಬೇಕು.
ಹಾ. ಅಲ್ಲ ಈಗ we are putting it very simply. Do you mean to say that this this 10% hike is from the 2017 accidents take place only after 2017 ಅಂತ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಆಗೋ ಆಕ್ಸಿಡೆಂಟ್ಸ್ ಗೆ ಅಂತ ಮಾತ್ರ
2017
ಅಂದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಈಗ ಲೈಕ್ ಲಾ that doesn't have any retrospective operation ಅಂತೀರಾ ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ಹೌದು 40,000 the aforesaid amount should be enhanced at the rate of 10% in every 3 years. ಈಗ what is the effect of operation of the judgments? Laws cannot be retrospectively operated, but what about judgment? We are not able to accept it. The accident of 2018. Are not laws do not have retrospective operation, but judgments operate retrospectively.
Even Supreme Court judgment on this like retrospective effect under set ಕೊಟ್ಟಿದಾರಲ್ಲ.
So now we are not inclined to accept that submission.
Actually settlement ಆಗಿದ್ದು 1,60,000 ನಾವು between 70,000 ಮಾತ್ರ ಪ್ರಣಯ ಸೇರಿಕೆ ನೀಡಿರುವ
ಯಾರು ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಇಲ್ಲ ನಾವು ಪ್ರೀವಿಯಸ್ಲಿ ಆಗಿರೋದಕ್ಕೂ ಕೊಟ್ಟಿದೀವಿ. ಎಷ್ಟಾಗುತ್ತೆ? ಹೌ ಮೆನಿ ಆರ್ 4 44,000 44 into 4 ಮಾಡಿ ಎಷ್ಟಾಗುತ್ತೆ? 1,76,000. ಈಗ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಎಲ್ಲ ಕೊಟ್ವಿ ನಾವು 1,76,000. ಉಳಿದೇನು ಇದ್ರಲ್ಲಿ ಬರೋದು ಬರೀ ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ ಸೆಕ್ಷನ್ 30,000. ದಟ್ ಈಸ್ ಎಷ್ಟಾಗುತ್ತೆ ಟೋಟಲ್? 18,28,164.
1,76,000
ಇದು 33,000 ಆಗಬೇಕು. 18,28,164 plus 1,76,000 plus 33,000. Correct. 33,000 correct. What is awarded? 7,77,000. So, what else? Challenging the adequacy of the compensation. Challenging the round ಮಾಡಿದ್ರೆ 164 ಅನ್ನ 16 ಮಾಡೋಣ ಅಷ್ಟೇ, 160 ಮಾಡೋಣ. ಚಾಲೆಂಜ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತು, ಮತ್ತೆ ಅವಾಗ ಯಾಕೆ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ನೀವು? ಚಾಲೆಂಜಿಂಗ್ ಏನು adequacy of the award compensation awarded to them by the tribunal. The claimants in MVC number 317 of 2019 and the file of Senior Civil Judge and MACT Holalkere have preferred this appeal. The appellants are White, children and father of deceased Umesh on 11/2/2018 at 1:45 p.m. when Umesh was traveling on motorcycle number KA16/EZ4169 which is the place of accident. Dagganahalli village gate. At Dagganahalli village gate, Bharati Brezza car number KA15/M9954 with the said motorcycle of Umesh. Whether he died at spot or he was taken to Shivaga hospital. On the same day, he died at 4:10 p.m. Due to the injury suffered in the accident, he died on the same day at 4:10 p.m. in the hospital, Meghan Hospital, Shivaga. At the relevant time, respondent number 1 was the registered owner and respondent number 2. Your owner cum driver, respondent number 1, he was driving the vehicle. Who was the driver of the vehicle? The records there. Driver of the offending vehicle, he was not driving. This man was not driving. The respondent number was 1 and 2 were the registered owner and insurer of the said vehicle. The appellants filed MVC number 317 of 2019 against the response before the senior civil judge and MACP Hodankere, claiming compensation of 55 lakhs on the ground that the accident occurred due to actionable negligence of the driver of car number KA15/M9954. They further claim that they were all dependents of the deceased. Here is income. What was his occupation and income? And consequently, they have suffered damages. Next one. That respondent. Avaru contest madidara. Ibru contest madidara. 1 and 2. Respondents contested the petition, denying the occurrence of the accident due to rashness and negligence on the part of the driver of the car, of age, occupation, and income of the deceased, and their liability to pay the compensation. The tribunal, the parties adduced evidence. Avarenu madilla evidence, only claimants have adduced. Claimant parties antara. Claimants adduced evidence. The tribunal, on hearing the parties, by the impugned award granted compensation of ₹7,77,000 on different heads as follows. Page 25 chart. The tribunal held that the accident occurred due to rash and negligent driving of the car by its driver, in the absence of the actual proof of deceased. Tribunal considered his income at ₹6,000 per month. 6,000 per month. 13 multiplier apply ಮಾಡಿದ್ದಾರೆ. ಡಿಡಕ್ಷನ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲಿ ನಾವು 1/4 ಮಾಡಿದ್ವಿ. Deducted 1/4 for his personal expenses. Applied a 13 multiplier. and assess the loss of dependency at 7,02,000. The unconventional heads, the tribunal awarded the compensation as per the above referred table. The counsel for the appellant, reiterating the grounds of appeal, submit that the criminal erroneously assessed the income of the deceased on the lower side. And even compensation awarded on the heads of consortium and unconventional head is on the lower side. He further submits that the tribunal has not awarded, the tribunal should have awarded future prospects on the income of the deceased. Per contrast, she so and so learned counsel for the second respondent, insurer, submits that justifies the compensation awarded. The findings of the tribunal that the accident occurred due to rash and negligent driving of the car number K15M9954 is not challenged and has attained finality. Even the age of the deceased, multiplier applied, and the deduction for personal expenses are not under challenge. The question is whether the tribunal was justified in assessing the income notionally at 6,000. The accident has occurred in 2018. Considering the minimum wage, cost of living, and other prevailing circumstances, the notional income considered by the tribunal is on the lower side. It should have been taken at ₹500. On deducting to the said income, which percent of the
25% is future prospect.
to the said income, a sum at the rate of 25% should have been superadded in view of the judgment of the Supreme Court in Safety versus National Insurance Company, citation of which comes to rupees
3,125. Both include 15,625.
out of that, 1/4 should have been deducted to the personal expenses. Therefore,
Net amount.
the 12,500 plus 3,125 minus 1/4 minus 3,906 and 11,719. And applying the multiplier of 13, the compensation payable on the head of loss of dependence comes to 11 into bracket 11,719 into 12 into 13, 18,28,164. In view of the judgment of the Supreme Court in Pranay Sethi's case, referred to Supra, and the judgment of the Supreme Court in Magma Insurance Company versus Nanoram. Compensation payable on the head of consortium to each of the petitioner claimants, appellants, is 44%. Therefore, the compensation payable on the head of consortium is 1,76,000. Compensation payable on the heads of conventional heads of loss, funeral expenses and loss of estate comes to is bracket only 30 plus 3,000. ಅದರಲ್ಲೂ ಅಷ್ಟೇ ಮೇಲೆ 1,60,000 plus 16,000, 33,000. Therefore, the just compensation payable is as follows: loss of dependency 18,28,164, loss of consortium 1,76,000, loss of estate and funeral expenses 33,000. Total 20 lakhs 37,160 rounded to 164, rounded to 20 lakhs 37,160. 160 rounded. The order of the tribunal requires to be modified accordingly. What's the following order? The appeal is partly allowed. The impugned award is modified as follows. The appellants are entitled to compensation of rupees 20 lakhs 37,160 with interest thereon at 6% per annum from the date of the petition till the realization. Respondent number 2 alwa insurer 2 shall deposit the said amount before the tribunal. Bracket ಅಲ್ಲಿ inclusive of the amount deposited if any already bracket complete for the tribunal ಅಂತ ಆಯ್ತಲ್ಲ within 6 weeks from the date of the receipt of copy of this order. Entitled to compensation interest ಹೇಳಿಲ್ಲ ನಾನು entitled to compensation of rupees 18 lakhs 20 lakhs 37,160 with interest ಹೇಳಿದ್ನಲ್ಲ
6%.
the award of the tribunal with regard to apportionment and investment is maintained.
The adjourned, deputy, party.
ಬೇರೆ ಇದೆ ನೋಡಿ.
ಮಾತಾಡ್ಮೇಲೆ
Number ಎಷ್ಟು?
1.
Admission register extract. Yesterday was there, no? Phone number. Tell here. Matriculation equivalent certificate from the school first attended or birth certificate by the corporation or panchayat. Only in the absence of such documents, medical opinion shall be heard. So it says that it should be decided based on the matriculation certificate or equivalent certificate or date of birth certificate. Either date of birth certificate is there, not or matriculation certificate is there. So medical examination report shall be relied only in the absence of these two ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲೇನು ನೀವು ಆಸಿಫಿಕೇಶನ್ ಟೆಸ್ಟ್ ಇಲ್ಲ. 15. Is there here? First be on the documents stipulated under Rule 12(3) of 2007 rules. Only in the absence of such documents, medical opinion shall be relied. What are the documents mentioned in Rule 12(3) of Juvenile Justice Act? Extract paragraph number 12 to 18. 776. Two certificates, birth certificate and middle school certificate. All three is extracted here, para 14 and in every case consider. One second. Again, rule first one is matriculation or equivalent certificates, if available. The date of birth certificate, second one. Other than a play school first attended and in the absence of birth certificate given by the corporation. So this girl had passed SSLC. She was in PUC. Your officer did not collect SSLC certificate. Yeah, since now they were married already. Now what is the position now? Whether they are living together or he could have. So even according to judgments, it was submitted firstly the matriculation certificate, secondly birth certificate or matriculation certificate. Only in the absence of that, the medical evidence has to be taken on the head. Illi school admission register, all that even admission original register is taken, that is different. Para 15. Modi. 12(3)(b), it is specifically provided that only in the absence of alternative methods described in 12(3)(a) 1 to 3, the medical opinion can be sought. So 1 to 3 alli adu ilvalla. See 1 alli matriculation or equivalent certificate if available. Number 2, date of birth certificate from the school.
Other than this.
And next birth certificate given by the corporation or municipal authority. The light of such a statutory rule prevailing for ascertainment of the age of the juvenile, in our considered opinion, the same yardstick can be rightly followed by the courts for the purpose of ascertaining the age of the victim as well. This court therefore relied on the certificates issued by the school in determining the age of the prosecutors. In para 30, Mahadev's case. First case, Mahadev's case. Only para 13 will extract ಮಾಡ್ತಾರೆ. In the light of above reasoning, in the case on hand, there were certificates issued by the school in which prosecutrix did her 5th standard, and in the school leaving certificate issued by the school under Exhibit P54, the date of birth of the prosecutrix has been clearly noted as 25/1990. This document was also put by PW11. We do not know who was PW11, but apart from that, transfer certificate as well as the admission form maintained by the primary school Latur, where the prosecutrix had her initial education, also confirmed the date of birth as 25/1990. The reliance placed on the said evidence by the courts below to arrive at the age of the prosecutrix to hold as prosecutrix was below 18 years was perfectly justified, and we do not find any grounds to interfere with the same. Only who was PW11 now? PW11 and rely ಆಗ್ತಾರೆ. The first case, the Supreme Court relied on the evidence of PW11. Who was PW11? Paragraph, expect para 13. The first case. What was that exhibit P? Exhibit P54 the trial court considered the evidence of the 112 and as well as exhibit P53, 54, 57 and concluded that at the time of the commission of offense, which commenced on 29th of June, continued till aged 15 years and 4 months. There, the counsel for the accused tried to rely on the medical report. So this is PW11 is the headmistress of so and so school, where the prosecutrix was admitted to 5th standard. PW11 produced exhibit 54. the school leaving certificate, he disclosed the date of birth of the prosecutrix as 20. In case only father has not supported, who gave those that information? The grandparents on the head. Even that girl says, yes, what could you find out? Whether now they are living together. Whether you are sure or not sure. Whether the accused and this girl, they are living together now. ಏನ್ ಹೇಳಿದ್ದಾರೆ ಇಲ್ಲಿ ಅವ್ರ ಕಾಪಿನೂ ಇಲ್ಲ ಅವ್ರಿಗೆ ಪ್ರೂಫ್ ಆಫ್ ಏಜ್. ದಿಸ್ ಇಸ್ 2020 ಲೇಟೆಸ್ಟ್. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು 2013 and 15. Leaving certificate transferred with its own for proving the date of birth insufficient. The absence of examination of the official in charge of school who recorded the date of birth in the school register. ನಿನ್ನೆ ನಾವು ಹೇಳಿದ್ವಲ್ಲ, ಅದೇ ಎಂಟ್ರಿ ಮಾಡಿದವ್ರು ಮಾಡಬೇಕು. Proving the records of school. Issue involved interview in the plaintiff's suit for actions. Copy of the public document as contemplated in section 76. Said to be signed by his father. So what section 35 says? Relevancy of those documents. The proof ಬಗ್ಗೆ ಏನಾರ ಯಾರು ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕು ಸಕ್ಸಸ್. ಬಟ್ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಯಾರು ಕೊಟ್ಟಿದ್ರು ಅವರೇ ಅದನ್ನ ಡಿನೈ ಮಾಡಿದ್ರೆ ಅಥವಾ ಅವ್ರನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ಡಿನೈಡ್ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಬೇಕು. Right, yesterday only we said, no? The thing is whether your client has any commitment, whether he is living with that girl or ಈ ತರದ ಕೇಸ್ಗಳಲ್ಲಿ ಎಲ್ಲ may be entitled to some benefit. He was also hardly 20 years. So yes, not a case for interference. Of course, relationship was admitted by the girl, but the prime factor was age. Right, that admission resist also. Who made those entries when the document was disputed? Who made those entries was to be examined, not the successor. Whether the trial court, whether the impugned order of impugned judgment in order of acquittal passed by the trial court in favor of the respondent is suffers any illegality or impropriety is the question involved in this case. The exposition will be right. The respondent hearing in special case number 13 of 2014 for the charges for the offences punishable under section 366 and 376 IPC and section 5(1) read with section 6 of the Page number 9 ಅಲ್ಲ? Nine, nine.
19.
Number 9 ಇಂದ ಶುರುವಾಗುತ್ತೆ.
9 ಇಂದ ಶುರು ಆಗುತ್ತೆ.
366 376 IPC and section ಅದೇನ್ ಚಾರ್ಜ್ ಅಮೆಂಡ್ ಮಾಡಿದಾರ ಆಮೇಲೆ 51 ಅಂತ ಮಾಡಿದ್ದಾರೆ 6 ಅಂತ ಏನು ಮಾಡಿದ್ರು ಆಲ್ಟರ್ಡ್ ಚಾರ್ಜಸ್ 366 376 IPC and section 51 read with section 6 of the Protection of Children from Sexual Offence Act 2012 into bracket for short Act 2012 on the basis of the charge sheet filed by which police this is? Udupi Town Police. Udupi Town Police in crime number 474 of 2013 of their police station. The case of the prosecution in brief is as follows. That case of the prosecution in the admit facts of the case are as follows. PW. One is the mother and PW. Father is PW 10 alla. Father is PW 12. Is the father of PW 2. PW correct. ಅಲ್ಲ ಅವರ ಆಂಟ್ಸ್ ಯಾರೋ ರಿಲೇಟಿವ್ಸ್ victims examination principal Rajesh Kai. PWL1 is the niece of father. There is our brain relative. ಅಲ್ಲ ಈಗ except PW1, 2 and 12 other related witnesses only PW this 11 Lakshmi. PW11 is the niece of PW1. The accused and the aforesaid witnesses hail from the same village, that is yavradu questions mark Ramesh entadadu Venakatte avunu he was a migrant. ಉಜ್ಜಾರಣ್ಯ ಕಾಡು ಅಂದ್ರೆ ಅವರೆಲ್ಲ ಮೈಗ್ರೆಂಟ್ ಲೇಬರ್ಸ್ ಅಲ್ಲಿ ಬಂದವರು. She was from Koppala district. He accused he is from Bagalkote district. ಅಲ್ಲ ಅದು ತಪ್ಪಾಗುತ್ತೆ living in ಅವಾಗ they were living in ಏನು ಮೂಡನಿಡಂಬೂರ್ ವಿಲೇಜ್ ಉಡುಪಿ ತಾಲೂಕಾ. Mudanidambur village in Udupi Taluk. They had all migrated from Bagalkote and Koppala district to eke out their livelihood. Complaint file ಮಾಡಿದ್ದಾರೆ. The case of the prosecution will be as follows. That the brother of the accused was helping. Our case alla adu nim case. He was helping another in case. That the accused and the aforesaid witnesses were acquainted with each other. PW2 She is born on PW2 was born on Looks wonderful.
96.
1996.
1896.
Date of offense, date. 1811, 1996. Was born on 1996. The accused inducing the minor PW2 of love and marriage. ಕರ್ಕೊಂಡು ಹೋದ್ರು ಅಂತ ಇದೆ ಅಲ್ವಾ ಇದರಲ್ಲಿ? As per the prosecution case, they had eloped. ಮತ್ತೆ ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಮಾಡೋವಾಗ 366 kidnapped her from the lawful custody of her parents. When she was going to the college, he took her to Goa. Date ಹೇಳಿಲ್ಲ, kidnapped her from on 18/11/2013, kidnapped her from the lawful custody of her parents when she was going to the college and took her to Goa. But they come back to Surat Kala.
ಇಲ್ಲಿ ಭಾಷೆ ಸರಿ ಒಂದಿಲ್ಲ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಸೂರತ್ ಕಲ್ಲಿ
Offense is 2011. Then he took her back to, then on 2011/2013, he took her back to near Surat Kali. Alla Bala andre adu one village.
ಊರ ಹೆಸರು.
To Bala village near Surat Kal of Mangalore Taluk. He stayed with her in the hut belonging to, he is not examined, CW9. CW9 Ravi alias Kenchappa. And during such stay, Ravi, he has not supported, correct, PW10 Ravi alias Kenchappa. During such stay in his hut, the accused committed penetrative sexual assault, repetitive penetrative sexual assault on her. Due to that, she conceived a child that was aborted. Complaint ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತಾರೆ? which date complaint was filed? Exhibit P1 105 to
26/12/2013.
20.
26/12/2013. ರಿಪೋರ್ಟ್ ಆಗಿದ್ದು 15/12/2013.
Regarding the incident, PW1 filed complaint as per Exhibit P1 on
15/12/2013.
15/12/2013. Date of eloping is 18/11/2013. So more than 1 month, around 1 month ago. It's of the said complaint, he registered the FIR as per exhibit P22. Conducted the W19. W18 is at page number? And handed over the investigation to PW19. The woman, the police sub inspector. Where they were traced. Yeah, which of the officers traced? I recorded when to go. PW1 took me to her house situated in Uddar and Nehru. Whether she traced the girl or the next officer traced the girl. Voluntary statement. Okay. PW19. PW19 during the course of investigation. Traced the accused and PW2 on 26/12/2013. From the heart of PW. Then subjected PW10 to PW2 to the medical examination. Arrested the respondent. Collected the copy of the SSLC marks card and produce mark ಮಾಡಿಸ್ಕೊಂಡಿಲ್ಲ. Lakshman gave me the copy of SSLC marks card and our evidence ಇದೆ. I headed over the further investigation. PW 20. The police inspector of Circle Police Inspector of Udupi Police Circle. He conducted the further investigation and filed the charge sheet for the aforesaid offences. The trial court, on hearing the parties, framed the charges against the accused for the offences punishable under section 366, 376 IPC and section 51 read with section 6 of the POCSO Act. Since the accused denied the charges and claimed that trial was conducted, to support to substantiate its case, the prosecution examined PW1 to 20 and got marked exhibit P1 to P26 and MO1 to 10. After his examination, section 313 CRPC, the accused got himself examined as DW1. On his behalf, exhibit D1 was marked by way of confrontation. D1 a bracket portion of statement of PW3 was marked as exhibit D1. The trial court, on hearing the parties, by the impugned judgment and order, acquitted the accused, mainly on the ground that the prosecution has failed to prove that PW2 was aged below 18 as on the date of the offense. To substantiate this case, out of the witnesses examined by the prosecution, PW1 is the mother of victim PW2. PW 10 is the father, PW 11 is the PW 12 is the father, yeah, right. PW 11 is the PW 12 is the father of PW 2, and PW 10, PW 11 is the niece of PW 1. PW 3 and 4 are the witnesses to the spot Mahazar exhibit P4. PW 5 is the doctor who examined PW 2 and issued the medical certificates as per exhibit P6 to 8. PW 6 is the doctor who examined the accused and issued a certificate exhibit P10. The effect that the accused is capable of performing sexual act. PW 7 is the principal of your college, principal of the college where PW2 was studying, and who has issued exhibit P7 report. What is exhibit P7? P7 is OPD. P7 is OPD check. ನಾನು ಇಲ್ಲಿ ನೋಟ್ಸ್ ಬರ್ಕೊಳ್ಳುವಾಗ principal of the college is PW7. What is his report? PW7 is at page number. No, PW principal. PW7 evidence ಯಾವ page ಅಲ್ಲಿದೆ? Page number 66. He speaks of what? Admission. ಅದೇ admission register copy ಕೊಟ್ಟಿರೋದು. I see the same. I have issued the certificate regarding date of birth. Issued the certificate exhibit P7 regarding date of birth of PW2. PW 9-8 is the PW7. PW8 is the assistant engineer who drew exhibit P2 the sketch of scene of offense. Exhibit PW9 is P4 no spot Mahazar, P2 is Panchat spot Mahazar exhibit P2. ಎರಡು ಸ್ಪಾಟ್, ಒಂದು ಗೋವಾದಲ್ಲಿದೆ, ಒಂದು ಇಲ್ಲಿದೆ, ಎರಡು ಮಾಡಿದಾರ. Exhibit P2 is at page number 107. ಬಾಳ ಅಲ್ಲಿದೆ. ಮತ್ ಮೊದ್ಲಿನ ಮಹಜರು ಆ ಮನೇನ what is that exhibit P4 ಮಹಜರ್? ಅದು ತಗಡ ಶೀಟು ಮಡಿಲಿನ ಮನೆ ಆಗಿರುತ್ತದೆ. ಆಪ್ಷನ್ ಫಿರ್ಯಾದಿದಾರರು ವಾಸವಿರುವ ಮನೆ, ಅದು ಸೀನ್ ಆಫ್ ಅಫೆನ್ಸ್ ಅಂತಂದ್ರೆ ಅಲ್ಲಿಂದ ಕಿಡ್ನಾಪ್ ಮಾಡಿದ್ರು ಅಂತ. ಎಕ್ಸಿಬಿಟ್ P4 ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಅಲ್ಲಿ the spot Mahazar drawn at the house of PW1 ಅಂತ ಮಾಡಿದ್ರು. ಈಗ ಹೇಳ್ಬಿಟ್ಟು P2 this is PW
PW9 is
the front witness to exhibit P2. Mahazar allegedly drawn at the scene of offense, that is Bala. That is the hut of PW. ಅವ್ರದೇ ಅಲ್ವಾ ಅದು PW ಒಂದ್ ಮನೆ ರವಿ ಕೆಂಚಪ್ಪ PW10 ಅದೇ P2 is that is PW10 ಸೀನಪ್ಪ PW ಆಗಲೇ ಹೇಳಿದ್ವಿ PW10 ಹೇಳಾಗಿದೆ PW10 who allegedly accommodated the accused in PW2 in his hut at Bala village. Shown in Exhibit P2, the spot was there. PW13 is the neighbor of PW1. PW14 is the headmistress of the school, where PW2 studied and issued the certificate Exhibit P19 and 20. ಯಾವ school ಅದು PW14? ಕುಷ್ಟಗಿ headmistress ಅಂತ ಹೇಳಿದ್ನಲ್ಲ of higher primary school ಹನುಮನಾಳ village ಕುಷ್ಟಗಿ ತಾಲೂಕ್ where PW2 studied. ಯಾಕಂದ್ರೆ ಎರಡಿದೆ ಅಲ್ಲ ಅವ್ರು ಮೊದಲು P7 ಕೊಟ್ಟವರು ಅವರು ಪ್ರಿನ್ಸಿಪಾಲ್ P7 ರಿಪೋರ್ಟ್ ಅಲ್ಲ ಅದೇನೋ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ P11 P7 ಅದೆಲ್ಲ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. That is at page number 120. Report ಅದು it's not even she did not appear ಅಂತ ಹೇಳಿ PW 15 and 16 are the women police constables who escorted PW2 to the hospital and for production before the magistrate. PW 17 is the FIR of the articles to FSL. PW 18 is the police officer who head constable who registered the complaint. PW 19 and 20 are the investigating officers. Out of the opposite witnesses, the evidence of PW so far as the sexual cohabitation between the accused and PW2, the evidence of PW2 and PW2, Dr. Vakil examined PW5 was material. Though PW2 turned partially hostile, she admitted her sexual cohabitation with the accused. But she claimed that herself she claimed that she was a major. Herself and the accused were in love, and that was opposed by her mother. Therefore, she eloped with him, and they married. ಎಲ್ಲಿ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ವಿ ಅಂತ ಹೇಳ್ತಾರೆ?
ಗಣಪತಿ ದೇವಸ್ಥಾನ.
Married PW2. Married each other in Ganesha temple of Bala village in Suratkal Taluk. Then they sexually cohabited with each other. In the light of such admission, such statement, PW1, PW. Doctor ಏನ್ ಹೇಳ್ತಾರೆ PW 5 ಅಲ್ವಾ PW 5 is at page number such admission 60. The evidence of PW 5 and her reports exhibits P6 to 8. P6 to 8 are at page number. Not 14, 114. But may not be correct in saying that this termination of pregnancy was not true, or abortion, not termination. So their medical reports only. Ultrasound reports. P6 to 8. Show that PW2 was subjected to sexual cohabitation. And she was found to be have conceived and aborted. However, the mute question was whether the victim was aged below 18 years. To prove the age of the victim, the prosecution relied on the evidence of PW 7 ಅಲ್ಲ that lady ಹುಲಿಗೆಮ್ಮ 7 ಅವ್ರು ನಮ್ಮ ಕಾಲೇಜ್ ನಲ್ಲಿ ಇದ್ರು ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಇವತ್ತಿನ ದಿವಸಗೂ ಅಟೆಂಡ್ ಮಾಡಿದ್ರು, ಆಮೇಲೆ she was not found ಅಂತ ಹೇಳಿ. PW 7 what he says, ಇಷ್ಟು ದಿವಸ ನಮ್ಮ ಕಾಲೇಜಿಗೆ ಬಂದ್ರು, ಆಮೇಲೆ they were not found ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. Did not attend the college. The date of birth as per our admission rules. Correct. PW1 PW1 PW7 PW Puligam PW14 PW father is PW12 and PW14. PW12, the father of the victim himself. Himself did not support the prosecution version with regard to the age. With regard to age, totally turned hostile. He did not support anything, including the age of the victim. He says that myself admitted her to first standard. He even denies that he admitted admitted PW to the school. And on the basis of information given by him, the entries in exhibit P18, the admission register extract were made. PW2 says that her grandparents admitted her to the school. The evidence of PW7 with regard to the date of birth of the victim is of no avail, because W7. The same was based is of no avail unless uh, her date of birth, unless the date of birth of PW2 is proved by her birth certificate or the admission register entry. PW14 is the to prove the admission register, school admission register entries. The prosecution relied on the evidence of PW14. The headmistress was working at the time of her evidence, and exhibit P19 and 20. P19 and 20. ಹಾಕಿಲ್ಲ ಅದಕ್ಕೆ. Uh, 19 and 20. Certificate. ಇನ್ನೊಂದೇನೋ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಒಂದು admission register ಎಲ್ಲಿದೆ ಅದು? 19 is 20 ರೆಕಾರ್ಡ್ ಅಲ್ಲ ಅದರಲ್ಲಿ P19 and 20. The certificate issued by her and 2014 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋ certificate. Issued by her to the IO on 19/3/2014 and the admission school admission register extract 19. Unless the entries in the school admission register extract exhibit P20 are proved. Exhibit P19 or 19A ಅಂತ ಇಲ್ಲಿ 19 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ P19 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ 19A ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾಕೆ ಇಲ್ಲ, ಇದು ತಪ್ಪಾಗಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. ಅಡ್ಮಿಷನ್ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮೇಲೆ P20 ಅಂತ. ವಾಟ್ ಇಸ್ ದಿಸ್ P19?
ಸರ್ಟಿಫಿಕೇಟ್
ಅಲ್ಲ, ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಅದ್ರ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಅದನ್ನ P19 ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ. P19 19A ಅಂತ. ಇವನ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ P19 is also certificate only. ಯಾಕೆ ಎರಡು ಸರಿ ಮಾರ್ಕ್ ಆಗಿದೆ? 19 ಇಲ್ಲಿ 19 ಅಂತ ಇದೆ. 19A ಸಿಗ್ನೇಚರ್ ಕರೆಕ್ಟ್ ಇದೆ, 19 ಅಷ್ಟೇ. 19A ಸಿಗ್ನೇಚರ್ ಓನ್ಲಿ. Exhibit P20, as per the entries in exhibit P20, the admission register extract PW2 was admitted. Date of admission ಏನಿದೆ? Admitted in the school during 2002-2003. ಅಲ್ಲ, ಇದು ಡೇಟ್ ಆಫ್ ಬರ್ತ್.
ಅಡ್ಮಿಷನ್
ಯಾವತ್ತಾಗಿತ್ತು ಅಂತ ಬರೋದಿಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ ಅಷ್ಟೇ. There her where that as per the said record at the time of admission of PW2, her date of birth was mentioned furnished as 1/8/1996. But PW14 is not the person who made the entries in exhibit P20. Therefore, her evidence with regard to entries in such entries in entry in exhibit P20 is only hearsay evidence. The PW14 does not know at whose instance who had furnished the information regarding date of birth. The IO has no explanation why he did not examine the person who made the entries in exhibit P20. Therefore, the evidence of PW14 and exhibit P19 and 20 were rightly rejected by the trial court. In the absence of those records, absolutely there was no evidence to show that as on the date of the offense, the victim was aged below 18 years. As per the evidence of PW2, she was admitted to the school at the age of 8 years. So if that is considered, then 10 years, 18 years completed. So the alleged incident took place when she was studying in 11th standard. Even on that basis, the probability is that she was above 18 years at the time of the incident. The Honorable Supreme Court, in a judgment in C. Narayana Reddy versus C. Jairam Reddy, 2024 SCC 659 has held that unless the official in charge of school who recorded the date of birth in the school register is examined, such record cannot be accepted in evidence as the proof of date of birth. Even in the judgments, ನೀವು ಅದು ಒಂದು ಸಾಕು ಯಾಕಂದ್ರೆ second judgment is rendered relying on the even in the judgment in state of Madhya Pradesh versus Anup Singh 2015 7 SCC 773 relied on by the learned HCP. It is held that to determine the age of the juvenile victim, the age of the victim are the juvenile in conflict with law. The documents to be produced or relied are the one contemplated in section 1(3) of the Juvenile Justice into bracket care and protection of children bracket complete rules 2007. The said documents are the matriculation or equivalent certificates, comma, the date of birth certificate from the school first attended other than the play school, matriculation certificate and in the absence of matriculation certificate, the date of birth certificate of the school where the victim first attended, and in the absence of that, the birth certificate issued by the corporation or municipal authority or panchayat. The case on hand, admittedly, PW2 had passed matriculation exams. The IO has no explanation why he did not collect the matriculation certificate in proof of date of birth of PW2. In the light of the aforesaid judgments and facts and circumstances discussed above, the trial court was justified in relying on the evidence of PW2 and the other material to hold that the victim was as an adult. Under circumstances, even if there was any sexual cohabitation between her and PW, the accused, such consensual sexual relationship does not attract. Section 376, even 366 of them. 376 are the provisions of the POCSO Act, are section 366 IPC. Hence, there are no grounds to interfere with the judgment. Hence, the appeal is the following order. The appeal is dismissed. ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ ಬರ್ತವೆ ಯಾಕಂದ್ರೆ ಪೋಕ್ಸೋಕ್ಕೆ
ಇದನ್ನು ಸ್ವಲ್ಪ ಮಾಡಿ ಇದನ್ನು ನಾನು ಕಳಿಸ್ತೀನಿ.
Yes. Between this one, is that other? Yes. Yes. So PW1 is the victim. Hostile. PW2. Mother of PW. Marimadaya. He has issued exhibit in Kotiradu. What is his report? School certificate. Exhibit test. Exhibit test. PW3. ಆಯ್ತು ಆಮೇಲೆ ನೋಡ
School certificate exhibit P14.
First time. Yes. Relative of attendance register. PW7. Landlady. Landlady na? Landlady. ಬಾಡಿಗೆ ತಗೊಂಡಿದ್ದು ಅಂತನಾ?
ಅವ್ರ ರಿಲೇಟಿವ್ ಇವ್ರ ಅಣ್ಣನ ಮಗಳಕ್ಕೆ ಅಣ್ಣನ ಮಗ
Accused.
Hmm.
None of the and relative.
ಆಂಟ್ ಆಗ್ತಾರೆ ಅಕ್ಯೂಸ್ಡ್ ಅಣ್ಣನ ಮಗ
What was it? PW8 is this? What was it? No, he was submitting that she is the owner of another house where this victim and accused live together. Page 99. Paper book page. PW ಎಷ್ಟು 8 ಅಲ್ಲ ಈ ಪ್ರಕರಣ ನಮ್ಮ ಮನೆಗೆ ಯಾವುದೇ ಹುಡುಗಿಯನ್ನು ಕಳ್ಕೊಂಡು Yeah, according to prosecution, she is the Mahazar witness plus here. ಅಲ್ಲ, ಇವ್ರ ಮನೆಯಲ್ಲೇ ಇಟ್ಟಿದ್ರು ಅಂತನಾ? PW9 is PW12. What is that spot Mahazar? Exhibit? P1. 12 ಅಂದ್ರಲ್ಲ ನಿಮ್ಗೆ ಲಕ್ಷ್ಮಣ. 9, 10, 11 is over. Yes.
Exhibit P3, Lakshmana.
To P3.
Hmm.
Yes. Yes, next PW12 is the Pancha to exhibit P3. PW13. What is that exhibit? P8 is a copy of attendance something. P8 North Coast. A copy of attendance register. Yes. Yes. You know, the admission register, what is that? P14? P14 is school
Shala
certificate.
Dakhla
School certificate. In a study certificate, with P14 is at page number?
113.
113 is deposition.
Hmm.
P13 another document. Got it. 207. Yes, school certificate. ಅದ್ರ ಮೇಲೆ ಶಾಲಾ ದೃಢೀಕರಣ ಪತ್ರ ಅಂತ ಇದೆ. Yes.